Hello? Hello? If you don't sit down, I'm going to start to sing right now, so. You know, the people who are upstairs can come downstairs because a lot of the people who are downstairs are playing hooky for the afternoon now that they've got their name signed on the they're leaving. Now, one thing, apparently there were some people who didn't register in the morning and didn't pay their fees. I've been asked to remind you that you have to pay your fees and to go and pay them before you leave. We have some major changes in the agenda, as you might imagine. We're starting at 2. We're going to do, in order to accommodate Mark Leach, who's coming at 4 o'clock to tell us about the future of legal aid and refugee matters, we're putting Nancy Goodman together with the first panel on the role of counsel. And are you going to go second or third? Rob is going first, Scott, then Nancy. Okay. So we're going to do that first, and we're going to try and keep that to a... Yeah, okay. We're going to go Rob, Nancy, Scott. And I'll explain to you what that's about. And then we're going to go right into federal court, and we're going to do the 2 seminars in one. And then we're going to do accounts and legal aid and future of legal aid at 4 o'clock. So we're going to close at 4:30, but there's going to be no refreshments. And we're going to sort of shorten everything a little bit, okay? And if we can live with that, then that's what we're going to do. Okay, we're going to have enough disruption from people continuing to roll in here. So I have to go up. I left something else. I'm going to, this session has to deal with the question of the role of counsel in refugee matters. And we have 3 speakers. Robert Adamson, who is with the UNHCR legal officer. He's a lawyer. And he's going to talk a bit about the role of counsel and problems he perceives. But Nancy Goodman is going to talk about opinion letters. And this is the concern of the area committee. Those of you who write opinion letters, either seeking legal aid to represent people at the full hearings, or in the alternative credible basis, or for federal court, we want to talk to you a bit, those of us on the area committees, about how the opinion letters should be structured so that we can make reasonable decisions on those matters. And then finally, Scott Kerr is going to speak from the point of view of complaints, the Law Society of Upper Canada. He's a supervisor of complaints, and he's going to talk about the whole issue of competence. And I have I'll be right back, and I'll start with Rob.
Thank you, Lorne. My perspective is rather unique in that I am a former legal clinic lawyer with a large refugee clientele, and I still have extensive contacts with the NGO community, but now I'm ensconced in the Immigration and Refugee Board, that is number 1 Front Street West, ground floor. Down there I have complete access to the documentation center, their computers. I get the statistics, and I get all the decisions. Now, as you know, the decisions are almost the written decisions tend to be negative decisions. So that gives me a good insight into what a failed claim is. You, of course, have more variety. You don't lose all your cases, do you? I would, as the program implies, and I would like to focus today on what you could be doing better, but if you're doing everything perfectly, then just wait for our friend from the Law Society. My first observation is that lawyers are not communicating with their clients. I get a steady stream of very confused people in my office. These are claimants who don't know, first of all, why they've lost. They then don't know who's going to do their federal court work for them, whether you're going to do it or whether there's somewhere else they should be going. And finally, they don't know anything at all about a possible H&C application. Now, I'm sure some of the problem is simply your busy schedule, but if it is something like a language difficulty, then of course you should be making better use of community resources. Most large Ontario communities have an active multicultural center of some description, and they're always willing to help. You might know that here in Toronto, Parkdale Community Legal Services are training, what is the phrase, culturally sensitive interpreters, particularly for Latin American, Somali, and Tamil cases. Make use of these resources. Because if you're not communicating with your client after the hearing, I wonder how you're communicating before the hearing. Again, I only see the negative cases, the negative decisions. I don't have access to all the documentation in the file, but I do see often in the PIFs, I do see in the PIFs in the reasons. As you know, many board members simply quote the PIF verbatim within the decision. That's complimentary in a way, but there also are a few problems. First of all, with basic English. Now, it's not so serious a problem as I originally thought, because when I went looking for good examples, I couldn't really find any. I'll read you one, though, that I turned up just before the Bar Association session in April. This is a quote from a PIF found in reasons, negative reasons, of course, in a Guatemalan case. When the guerrillas arrived, I thought at first there were just a few of them, but then I realized there were many. They came on a Saturday, which was payday. At first I thought they were robbers because they came on payday, but then I knew they were guerrillas because they were wearing their uniform with badges on their arms. I first thought they were robbers because they came on payday, but then I saw the badges. I knew they were guerrillas. There was about 200 of them. Now, you could shorten that a bit, right? Then there are problems that turn up in the reasons having to do with internal inconsistencies in the PIF. By that I'm referring to discrepancies or inconsistencies between sections of the PIF itself. You heard, for example, earlier about question 28, question 29. Here's a case where the answer to 29, have you ever committed or been convicted of any crime or offense? No. 28, are you or were you wanted by the police or military or any other authorities in any country? Answer, no. The very end of the PIF, though, he goes on to say, if I must return to Syria, I believe I will be arrested, tortured, and killed by government security police due to my political views and activities. You might think it's not an inconsistency. It's obvious that the man is talking about a fear of the Syrian authorities, but yet in the reasons we find the panel notes that the claimant, in response to question 28 of his PIF, testifies that he was not and is not wanted by the police or military or any other authorities in any country. The panel is satisfied that the claimant is not wanted in Syria by the authorities. Well, then there isn't much left to the claim, is there? Of course, a more difficult case is where the PIF doesn't reflect what the claimant is going to say in testimony. I have lots of many more examples of that type of problem. I realize when you can't do much about a spontaneous outburst by your client, but however, you should, when in preparing the case, go over carefully for example, the sections on schooling, work history, places of residence, because they all must fit in, they all must coincide. You must as well pay attention to the passport and passport sections and the dates of leaving the countries. The UNHCR, for example, is very suspicious of a claimant who says, I had a problem on July the 1st. On July the 10th, I was winging my way to the US with my brand new passport and a student visa. Because, of course, it takes much longer than 10 days or a month even to get a passport and a student and American visa in most countries. Now, it was mentioned this morning with reference to the Rajaratnam claim that not enough country documentation is going in. I have no personal knowledge of that particularly because this would be a deficiency in the record that would come to light in federal court. I do know, however, that you've got to do the basic background checking on the country. You've got to make use of the documentation center first and foremost, but there are lots of other resource centers around. I will give you one other example. I like this one. This is another negative decision, a Salvadoran case where I think someone missed something rather basic. Again, this is the PIF being quoted in the negative decision. The environment in which the following events took place must be properly understood. In my country, El Salvador, there was a constant state of fear, including physical violence and death, particularly because of the aggressive hostilities by the anti-government guerrilla forces known as the Contras. Could have sworn they were Nicaraguan. You also, in general, seem to be ignoring problem areas like, or in some cases, ignoring problem areas like torture and sexual assault. You have in the material the letter from the Canadian Centre for Victims of Torture. It's an excellent resource, not simply because they provide medical reports, but also because they have an extensive volunteer network that will help the claimant. As for sexual assault, you might know that the IRB has had extensive training on this area, this aspect to a claim. They've had several workshops, 4 in fact, all of which are on video. They've looked in, they had a basic session at the beginning focusing on women from different countries. They've done follow-up on Sri Lankan, Iranian, Somali, Latin American claims. Professor Hathaway, I understood, went and spoke on gender-specific claims, and more recently they had two senior UNHCR people from Geneva come and speak about this type of claim. You might ask yourselves whether you are as well prepared as the board to handle a claim where sensitive areas like torture, sexual assault come up. Might be a subject for another session, I suppose. I think that's all I have to say. Thanks.
Okay, well, it's not at all clear that these are totally connected, but maybe they are, and we're going to have... I think they are.
I think that they are connected, Lorne. I'm a member of the area committee, and I've been asked to speak to you about opinion letters, and I'm happy to do that because as a member of the area committee, I do see many opinion letters which I don't consider satisfactory. There are some materials. There is a copy of the opinion guidelines, and I'll be referring to those for federal court applications. There are 2 opinion letters that I've asked to be copied for you. One is, the longer one is directed to the area director, and that's an opinion letter which I consider to be a good quality opinion letter. The second is in the handouts. I'm sorry. It's a package in the handouts, and it starts with area director.
It's in the front cover, okay?
The second letter was taken from my most recent area committee meeting of this week, and as does not constitute an acceptable opinion letter. I'm going to go through them a little bit, and then finally you have the Espinoza decision, which I'll refer to. Let's look first at the opinion guidelines, and I'd like to make some comments. The time limits, it says that any time limits for filing should be clearly stated at the beginning. Please, it's a waste of the area committee's time to go through the documentation to try to figure out whether or not an extension of time is required. If there is an extension of time required and you haven't addressed that issue, then we will be sending that back for your opinion letter to be a second opinion letter to address that issue. Length of opinion letters, most people can deal adequately in 5 pages with an opinion. Copy of decision. We can't possibly assess a case on the basis of an opinion letter without a decision, the reasons, and if we don't have the reasons, again, we will not be making a decision, and given the time limitations involved, that's certainly going to put your client in jeopardy. Fourthly, we have background, and it says summarize briefly the facts of the case. I would add to that the facts of the case as presented to the tribunal. I'm sure that's obvious to many of you, but we're not interested in the facts as you generally know them. We're only interested in a summary of the facts as they have been presented to the tribunal. Also, you can assume that the area committee has read the reasons and has read them most likely before they've read your opinion letters. So if there are facts in the decision, for example, if most of the PIF has been reproduced, then it's not necessary for you to repeat those facts. Just refer us to the pages that contain those facts, because then we can get to the heart of your opinion, and you can't hide from us whether or not, in fact, you have an opinion, because very often, unfortunately, we get very, very lengthy recitation of facts and very little in the way of dealing with the merits of the case. I'm not saying, obviously, that if there are facts which haven't been dealt with by the tribunal or have been misstated by the tribunal or ignored, then that you should not set those out. Those should not only be set out, they should be set out very clearly. After background, we have grounds of appeal. I would add in there another heading, which would be documentary evidence. And here you should summarize briefly the documentary evidence. Again, not all of it, but that which is relevant to the appeal, judicial review. Counsel often fail to make clear to us whether this is they refer to documentary evidence, and it's not clear whether this was documentary evidence which was before the tribunal. And evidently, you're going to want to choose that which is critical to the appeal. So, for example, if the tribunal has made a finding with respect to country conditions which does not accord with the material that the tribunal had, then obviously we want to know about that, and you're going to want to highlight that. Then you have grounds of appeal, a number of examples. These aren't prioritized in any way. Ideally, what you want in an opinion letter is issues 1, 2, 3, 4. Each of them set out separately from each other, and the issue, why there's an error, and reference to the case law. It's a very straightforward approach, and it's one that if you take, makes our work easier, and also it's the approach that you have to take in order to prepare successful documentation. Under case law, it says if there is relevant case law from the federal court on a particular point, it would be helpful if counsel cited it. Well, I'm hoping that next time around that will be omitted. I think that that is a total understatement. In far too many instances in the area committee, we see errors outlined without reference to case law, and cases on point do exist. And without those references, it is honestly not clear to the area committee that the legal issues are grasped by counsel and that there's really any strong chance or good chance of likelihood of success in the application. You have very easy access to cases. Please remember to use the research facility. Not only are there a number of very good memorandum, which will give you a beginning, and many of the cases that are set out in those memos are not set out in opinion letters, even though those issues are being dealt with. In addition to this, you often can get individualized research almost immediately if someone else has already requested research on a particular point. So I strongly suggest that in any area in which you're not familiar with the law, you consult the research facility either before doing your own research or at least in conjunction with doing that research. The two opinion letters, the first one directed to the area director, as I said, I consider a good opinion. It follows the guidelines, and if you look at it, I'll leave you to read it yourself, but right from the beginning, the first paragraph identifies the type of case. The second paragraph says what type of certificates requested. The third notes that the board's decision and reasons are included. The fourth sets out the material on which the opinion is based. The fifth gives you time limits. And then the facts are set out quite briefly. The next page, the documentary evidence is set out, and in this particular case, the documentary evidence was very important to the arguments being made on appeal. And then page 3, grounds for appeal. First issue, second issue, third issue. And with each of the issues, there's a reference to the page of the board's reasons and the issue that's raised at in that particular page. And then there is a discussion of what the error is and an outline of the error along with the case law. We may not always agree with the arguments that are being made, but when you see this type of opinion letter, you know that counsel has thought carefully about the case, and it gives you much more confidence in their possibilities of being successful. If you look at the second opinion letter, based on this letter, I think that there's no reason to believe that leave would be granted. It is, first of all, there's almost none of what we've just discussed in this letter. There's a recitation of the facts, most of which were in the decision itself, and that takes up page 1 and most of page 2. We get to the bottom and we have, under the heading of the decision, really just a mention of what the board statement is that's being attacked, but there is no addressing of the issue, there's no analysis, there is no case law. And unfortunately, there are far too many cases where the area committee is seeing opinion letters where council haven't identified the issues, or if they have, they haven't analyzed the errors, and they haven't given us any supporting case law so that we know that they've grasped those issues. So quite frankly, when we get a letter and the critical errors are misstated, or some of them are ignored, or where some frivolous arguments are being made, the area committee will not grant a certificate even if it feels that there is a meritorious case. However strong our concern is for the refugee claimant, there's just no use in issuing a certificate if council hasn't properly grasped the issues and presented the arguments in an opinion letter. Federal court is overloaded. I don't think anyone is naive enough to suggest that the justices are going to look for issues that you haven't presented and grant leave. So in these situations, you're most likely to get a request from the area committee for a further opinion. And of course, this means that you're going to have to request an extension of time to file materials in support of the application for leave. You're putting your client in jeopardy, but it's your responsibility. And as much as a member of the area committee, I hate to see a case where there's clearly an arguable situation and the client may be put in jeopardy. I know the reality, and the reality is whether I'm sympathetic or not, if you haven't done your job, there's no point in our issuing you a certificate. I think when I mention the issue of extension of time, it's appropriate to mention the Espinoza case, which is also appended. And Espinoza was a case which involved a request for an indefinite extension of time on the grounds that a legal aid application remained undecided. Mr. Justice Mahoney is quite critical both of slow processing by the legal aid area committee and also slow processing by council. And he makes it clear that he's going to want details of the legal aid application process where you're requesting an extension of time based on the waiting for an opinion letter to receive approval and a certificate from legal aid. So you look at that decision at the bottom of page 2 and the top of page 3. He says, it seems that if an extension of time is sought to permit a legal aid application, it's necessary for the court to know when the application was made, why it was not made when the leave application was filed, when the area committee will have an opportunity to deal with it, and so on. So I think this is another encouragement for people to take seriously the timing with respect to processing of their applications. I don't want to run over time, just to mention as well, tapes are now available and you can get them within 3 or 4 days. It is not of use to the area committee to see an opinion letter which comes from counsel who is not counsel of record based on what a client has told them has occurred at the hearing. You do have time to get those tapes before the opinion letter, or at least to let us know why you don't have them yet in terms of giving the opinion, and let us know that you've requested the tapes. Certainly there may be circumstances in which that will be difficult, but at least let us know so that we know you're on top of it. Sometimes council don't even tell us whether they've made that request or not, and we're not confident that that's occurred. Final point, if the statement of fact and law has already been prepared, when you are making the request, the area committee doesn't want to encourage retroactive filing, but if you have prepared those documents, then as far as I'm concerned as a member of the area committee, I want to see those. What better way to make a decision as to whether this is a case on which a certificate should be allowed? And if I'm sitting on the committee, I will send it back and request those materials. Please send those as well. I have lots of other things that I could say, and I won't, but one last comment. Experienced people really are needed on the area committee. There are lots of cases to deal with. I can't say that I find it the most pleasurable of my tasks, but it is certainly a useful one, and I think that anyone who feels that they are in a position to help out, please let the area committee know. Thank you.
Who should they should
Well,
speak?
you could speak to Russ Otter, I think.
Yeah, okay. If you want to get on the area committee and you think you're qualified, call Russ, 5980-200. Just ask for Russ, you know. He's not here, right? Okay. One thing though, just one final comment. I have got extensions of time on the basis of not having gotten legal aid, but what I did do is I made sure that the court knew that I had applied for legal aid in a timely fashion, and I put in the affidavit that the Toronto Legal Aid Committee is overwhelmed with applications, and they've got so many, and although they sit every day, they can't possibly deal with them all. And on that basis, I was given an extension. But I think it's important that you put in the if you are applying, so I'm saying that if you get stuck, you can ask for an extension, and the court's not going to say no as long as you tell them that show them that you've acted in a reasonable fashion.
There was an extension granted in this case.
Yeah.
I'm not suggesting you won't get one, but you're going to have more difficulty if you
Right.
can't follow your steps.
No, but I think it's important you show the court that you've been conscientious, and then you shouldn't have a problem getting an extension. Okay, no, we'll take all the questions at the end because we have to move on to item number 3. The tomatoes are no.
I'll try to be brief. I just want to give you a very brief explanation of what the complaints department is all about and how it relates to you as refugee lawyers. A little closer. Okay. And the rest of it can be answered by questions, hopefully, if you have any. I just want to indicate, firstly, that the Law Society has about 20 or 25 investigators that deal with all kinds of complaints, whether they're refugee-related or otherwise. At any given time, there are about 6,000 files opened and being investigated by staff. I would say that right now, if we have 100 refugee-related complaints, I'd be surprised. It's a very, very low number. It probably is representative of the number of lawyers who actively practice in this area. I don't have any explanation why that number exists, why it's not higher, why it's not lower. I suppose that maybe some of you have a better idea about that than I do. Yeah, well, there's that. There is that. I mean, that's one possibility. The complainant will be out of the country forever.
Have you ever had a complaint from someone outside of the country?
Oh yeah, sure, yeah, no question, from their place of origin on some occasions, but it may mean that you're doing a great job. I mean, I think I'm not sure whether that's true or not. I'm sure most of you are, but if this aspect of the bar is like any other aspect of the bar, there are refugee lawyers who are not serving their clients well, who are doing a disservice to their clients, and who are doing a disservice to the legal profession as well. I think one of the problems we've got, and it's affecting all areas of law, and including the refugee area, is the delivery of competent and quality legal services to clients. Programs like this are aimed directly at addressing that issue, and I think it's great that you had such a great turnout. I understand that it was mandatory attendance, which might explain part of that, but I think it's a great idea. Nevertheless, and we'd probably have fewer complaints in other areas if they had initiatives of this kind. A few of the things I want to touch on. First of all, I want to discuss briefly the types of quality service complaints that we're getting. But before I get to that, I want to stress that I think it's very important that as lawyers, you have to remember that we're all involved in regulation. This is a self-regulatory profession. Like everybody else and like everyone in this room, I've heard rumors, I've heard oblique references and murky stories about incompetence and misconduct among the refugee bar. It doesn't have the greatest reputation, as I'm sure you're all too aware. We hear those stories. They're not being reported to us, though. No one is reporting them to us. And if they're happening, and you, as members of the refugee bar, are aware of things which you believe are atrocious or disconcerting or whatever, and you're not reporting them to us, don't complain about how ineffective the Law Society is in dealing with the bandits in the refugee bar. Because, like I say, we got 25 investigators for any complaint you want to name, whether it's a real estate complaint or a refugee complaint. We need direction, we need input, we need assistance from our own members, or we're not going to be a very effective regulatory body. And, you know, quality of service complaints in particular are very concerning, and they go to the heart of self-regulation. And if we're not doing our job as lawyers in policing ourselves, you know, I mean, it kind of questions the point of self-regulation to a certain extent. I leave that with you. I'm sure that none of you would look forward to reporting a fellow solicitor to the Law Society. It's a very serious matter, and people do it with great reluctance, and understandably so. But I just leave that with you for what it's worth. Getting back to the types of complaints we get, as I indicated, most of them are quality of service types of complaints. Most of those are from members of the public who were clients of lawyers. We do get a few complaints from lawyers about previous lawyers and what a lousy job they did, but that's very rare. Most of the complaints we do get relate to areas such as excessive fees. Clearly that would be non-legally aided clients. An insufficient, a total lack or a deficiency in the amount of communication between lawyer and client, which leads to all kinds of other problems, some of which have already been discussed today, I understand, in terms of the accuracy of legal aid opinion reports and the accuracy of documentation contained in the PIFs as well. Delay. A lot of complainants or a lot of the complaints that we do get deal with adjournments being called for by the lawyers over the protests or the objections of their own clients, who are in most cases very anxious to have these matters disposed of. Lawyer not showing up for a hearing. We get a few of those. We've been getting more lately. Certain complaints related to legal aid. Most of these are referred directly to the legal aid plan, who have their own investigative resources. So I refer that to you. Some complaints we get about the law clerks and paralegals employed by lawyers, and the amount of supervision or lack thereof that these people get. As well, we do get a few complaints about the relations between lawyers and independent immigration consulting firms, and allegations of fee splitting and sort of behind the scenes wheeling and dealing between lawyers and people in these outfits. And finally, I think the classic complaint that complainants of all stripes make to the Law Society, and that is about overblown and overly optimistic representations made by lawyers about the prospects for success in their client's case at the outset, which often come crashing down at some later stage in the process. The rules of conduct sort of caution you against that, and I know a lot of the times the client will come in and give you a story which, based on your assessment of the facts as described at that time, will make you fairly optimistic. Obviously, a lot of these facts ultimately turn out to not be true or to be less than accurate, and which changes your version of the facts, but the complaint's in the mail by then. So those types of complaints, all relating to quality of service, are the ones that we deal with most of the time. By and large, those will not result in disciplinary action. At least a single solitary complaint of that kind will not result in any type of disciplinary action. We normally will require a detailed explanation from the lawyer about what really happened, or according to them what happened. But for us to really be effective in dealing with these types of problems, we're going to probably have to get a pattern of these types of complaints in order to substantiate that there actually is a quality of service problem with this lawyer and how they deliver services to clients. And if we do get a number of complaints of that kind, we've got a couple of options, but probably the most effective one, and the one that we're going to start using more and more often, are the services of the Professional Standards Committee. And the Standards Committee has an operation called the Practice Review Program, which is a form of voluntary peer review where we send in a lawyer from private practice to give us a full-blown assessment of the problem lawyer's practice, so that we can sort of tailor a remedial program to address that specific lawyer's concerns. As I said, this program presently is a voluntary program or a consensual program. There is proposed legislation, however, which we're going to be sending to Queen's Park this year, which will make that program mandatory. So if we identify lawyers who have competency problems in this area, they will be obliged to participate in programs of this kind. So that's something that's on the horizon. Probably in dealing with quality of service complaints, that's going to be the most effective means of dealing with these problems, because the disciplinary course is not terribly effective. It's been proved not to be effective, and we have to try more creative and innovative ways of dealing with the problem. The other types of complaints we get fall into a much lower percentage, and they would deal with dishonesty on the part of the refugee lawyer. This is very rare. Allegations about false information contained in PIFs, or deficiencies in PIFs, the signing of blank documents or incomplete documents as part of the refugee claims process. Matters of that kind are reported to us. Obviously, if these complaints can be substantiated, they could very well result in disciplinary action against a lawyer, because there's an element of dishonesty there in that type of conduct. The last area that we get complaints in, and these are the ones which are generated by lawyers against other lawyers, is the seeming growth industry in the number of complaints about scooping clients. This appears to be a direct consequence, or at least a partial consequence, of the designated counsel programs operated by the Ontario Legal Aid Plan. And this particular problem is being dealt with on a number of different fronts. Some of you may question how effectively it's being dealt with at this point, but it's an ongoing problem, it's a complex one, and we're all trying to deal with it. Of not much particular use in dealing with the problem are the rules of professional conduct, which deal with things like solicitation and touting in a manner which I don't believe are particularly suited to the specific problem of solicitation in this area. I'll be pleased to elaborate on that at some later time, perhaps later on today if you want, but I think I'd better call a stop to this right now.
Okay. We have time for a few questions.
I have one question with regards to the request for an extension of time to file your memorandum and your affidavit materials to put a report of appeal. Is the appropriate time, if you know you're going to need it, to put it in your notice of appeal?
Okay, I'll deal with that. The next topic is federal court, so ask that question. That's more appropriate in that part. The question had to do with practice in the federal court, and we'll leave it to the next session, which is just coming up as soon as we finish this. But let's deal with practice matters now. To what extent do we get opinions that after considering all the matters we decide at the area committee it's not worthy of legal aid?
I guess the question is what percentage of opinion letters are refused certificates?
No. Where the lawyer says there's no merit?
Probably we would get one or two of those on a list of 20 or 25 matters that we deal with each time.
Yeah, that's one thing you people.
Now, I must say, though, that doesn't always mean that the person won't get a legal aid certificate. There have been times that it seems that the lawyer is out of time in the application and has given that opinion to protect themselves rather than because of the merits of the case. So an alert area committee will not always simply go along with the opinion of counsel.
Yeah, but there's one thing I wanted to point out. You know, area committees are dealing with 20, 25 matters a night. So the more complete your opinion letters are, the more happy the area committee is going to be to give you a certificate. I mean, if we have to read through 20 opinion letters and you haven't given us anything in which, and we're trying to guess whether there's something there or not, we're not going to be too well disposed towards granting a certificate. I mean, the sad part about it is your client suffers for your lack of competence in preparing the opinion letter.
If you enclose your PIP, you enclose the reasons, and you enclose your leave to appeal application and your affidavit is in court, I sometimes feel like repeating myself in my opinion letter.
Please don't, I mean, the opinion letter, if you actually have the memorandum done, then you have to say almost nothing in an opinion letter. We can read a memorandum and figure out, absolutely, you just say, I enclose the documents that I filed. But again, I know I'm being asked by the area committee in general, we're not encouraging people to file and ask for retroactive coverage. And in fact, if you haven't done an application, which is a good application, whether or not you've done the work will not be the ground on which you'll be granted a certificate.
The question is, if it's a negative opinion letter, should you make us complete an opinion letter?
In the past, what I've done, is I don't think it has any merit. I send the client away, essentially. You really don't do anything. But I'm wondering whether that's appropriate under the certificate they've got, and how much of a letter
Okay.
would you expect?
The question is, if you've been retained to do by a client to do an appeal and you're given a certificate for an opinion letter, how much should you put in if after you've done all this you decide there's no merit in terms of the opinion letter?
Basically, obviously, it's not going to follow the same format, completely the same format. You're not going to be able to outline grounds of appeal, but you may be able, you should alert us to grounds that if there are any that you think aren't going to be successful, you should put those in. And certainly, if you can't find any grounds, you have to tell us that you can't find any grounds. It obviously can't be as detailed. But we do appreciate knowing, since you are getting reimbursed for the opinion letter, that you have given it some serious consideration. And that's not always the case. Sometimes we get a one paragraph negative opinion, and I'm not very confident that counsel has necessarily directed their mind to the issue.
Okay. Oh, you had a chance, Jerry?
Just to add that I think sometimes the area committee will send a certificate for another opinion.
Yeah. The comment was that in some cases the area committee will ask for a second opinion if they're not satisfied with a negative first opinion. Okay.
Of another lawyer.
Of a lawyer number one. Yep. Okay, what I think that's the question was, why do I have to give an opinion on the merits after leave has been granted? I think that that's the standard certificate that's issued in all cases, but if you put in your opinion letter that leave has already been granted, and obviously the federal court has determined that there's merits, far be it for the area committee to disagree with the federal court. So I think you just put in an opinion letter saying that, and I think that should be sufficient. And I mean, if I were on an area committee knowing that we approve far more people get legal aid to do leave applications than get leave to appeal. The acceptance rate on leave to appeal is 25%, and I would be willing to say that the acceptance rate on the area committees is way higher than that. Does someone know what the statistics is? No. Okay, but I'm sure it's over. In any committee I'm sat on, it's over 50%. So that what we're providing coverage to a lot of people who don't. So that means that if you've already got leave, just say that and you'll get a certificate. I don't think any area committee.
There's no question about that.
That's for you. I don't know. The question is, if legal aid refuses a certificate, can the solicitor asked to be retained privately. Is there anything wrong with that? I don't see anything wrong with that. I mean, you know,
Usually the order is the other way around if the person has said that they need a legal aid certificate.
yeah, but sometimes. Oh, well. Well, I mean, the suggestion there then is that how could a client who qualifies for legal aid and is then turned down somehow afford to retain you privately? Well, I mean, family, friends, begging, boring. I don't know.
Hold-ups.
Is there an ethical problem there?
Well, no, I don't think so. I mean, yeah, as you say, I mean, they can get the money from any kind of different source. If it's not a personal source, I mean, maybe it's a friend or a distant relative. I mean, who knows? There can be all kinds of different sources of funding.
No.
No, that's enough. It's enough. We're running out of. We're running out of.
Yeah?
No. I'm sorry. There's lots of other questions here, and go ahead.
It's the fact that most refugee claimants do not have the money to fund an appeal and they rely on legal aid. Does it concern the area committee that they're really now acting as the judges and jury on a case rather than the judge himself? Because if funding is denied, then usually they can't proceed with the appeal. Does that make sense?
Well, the question was to repeat the question, and then I'll let Nancy answer it. Does it concern the area committees that they're actually acting as judge and jury, because if they deny funding, the person won't be able to get his appeal done?
Well, let me say two things. First of all, the standard is a completely different standard. We're not determining whether you're going to be successful on an appeal, but whether you have an arguable case that a person of moderate means would put forward. And given that a refugee claimant, the consequences to a refugee claimant are so tremendous, that obviously goes into the picture and makes it more likely that we're going to consider issuing a certificate. I find I'm very tense when I sit at the area committee. I find it a very difficult situation to be in, but I particularly find it difficult when council aren't doing their job. That's what makes me nervous. And so I put it back to everyone who makes an application for legal aid to say, you should be nervous because it's your responsibility. We can't take over the case. There are many instances in which what we would like to do is suggest the grounds and make the arguments. That is not our function. We can send it back and say, we would like to hear on this issue, we would like to hear on that issue, but that's even more than many area committees will do. Yes, I don't like the situation, but that is the situation, and that's why I'm here today urging council to do a better job, much better job than is in that opinion letter, and that is not an extraordinary opinion letter.
Okay. Anything going once? Last question up at the back. All right, the question is, because for the people upstairs, hi up there. Given the very grave consequences of incompetence on the part of a refugee lawyer, where incompetence could result in the person's life being put at risk, I think it's directed to you, Scott.
Yeah.
What, in terms of the possible repercussions for the lawyer, are they? I mean, the punishment's satisfactory. I guess that's the question. Yep.
It would probably be a factor in assessing penalty against the lawyer. I mean, if the lawyer, if we could establish, if it was established that the lawyer was guilty of professional misconduct in that he failed to deliver a standard of service which was acceptable, then he or she would be found guilty. Then it would come to penalty in assessing penalty, the consequences for the client who suffered as a result of that incompetent service would probably be weighed in the balance when they were assessing penalty, and it may be an aggravating factor in penalty. That would be that's how it would be dealt with, I think.
The bottom line, though, is if we mess up, our clients pay a far heavier price than we're likely to ever pay for our mistake, if they are real refugees. So that's why we're all here today, right? Okay. Moving along to the next, I would like to thank this panel. And moving along to the next panel, this is the one you've all been waiting for on federal court. I'd like to call Barbara and Lee Taylor to the hot seat. You want to do that? Yeah, go ahead. We have a brief interlude here, so while we're doing that, we have a question for you from Patricia.
Just wanted to know from you, by a show of hands, if you would be interested in subscribing to this publication. If, yeah, well, I told you earlier on it would be $110, but we need to have an indication of numbers before we can proceed with sort of wider distribution.
How often is it? Every 6 weeks?
It's about every 6 weeks.
So
And the plan, if there is interest, it would be to expand this publication to include a lot more decisions.
So the question is, by a show of hands, how many people would be willing to pay, I mean, I'll be blunt, $110 a year to receive that every 6 weeks, something similar to this? The board needs to know this so that they can decide whether they want to offer it to us. Every 6 weeks. Approximately, how many is that? 6 divided by 50, 9 times a year, right? Yeah? 50, yeah. 9 times a year. Ready? Yeah, how many people upstairs are all the people upstairs downstairs, or are there still people upstairs? If you're upstairs... Are there people upstairs still? Okay, would you hold your hands up again, because we need to have a rough idea here.
Is that about a third, you think?
No, it's more than that.
About half the people?
I would say half. Half.
Thank you.
Okay. I know this is the part you've all been waiting for, right? Federal court. Right. Okay. What we're going to do here is converge the stays and practice and stays into one thing. And I'm going to go through procedure really quickly, and then we don't have Ursula, we have Lee Taylor, who is a worthy opponent from the Department of Justice. You know, and she's going to tell us all the things that they see that we do wrong. That's my favorite part of the day. And then we get to tell them all the things that we see that they do wrong, right? No. And then we have Barbara, who's written a paper on stays that she hasn't yet finished, but it's here in rough draft and will be distributed to everyone later. Okay? And what we have in the materials is I reproduced a whole copy of one set of applications on stays together with my federal court paper. So let's start at the beginning and go through this whole thing in terms of federal court practice. Okay, you get a client who comes into your office and he says, I want to appeal to the federal court. So where do we start? First of all, which part of the federal court are we appealing to? And I'm only talking about refugee matters now. We'll leave immigration aside, okay? So the first thing we have to do is, where are we going? And that depends now on the tribunal that the decision has come from, okay? If the refugee has been turned down by an adjudicator sitting with a board member at credible basis, then according to the new Federal Court Act, that goes to the trial division pursuant to section 18.1 on a leave to commence an application for judicial review. So the first thing you have to do when your client comes in, because I get calls all the time, I want to appeal. So they come in and you say, well, where was this decision taken from? And usually you can tell the difference, because if it's from the credible basis, you don't have reasons for decision, and if it's from the CRDD, you would have a nice, 7 or 8 page decision. So that's how we can tell, right? So that if it's from credible basis, it goes to the trial division under section 18.1, an application for leave to commence an application for judicial review. And if it's from the Convention Refugee Determination Division, it goes to the Appeal Division. Now, there's a little twist here, of course. 99.9% of the time, the Convention Refugee Determination Division will say the person is not a convention refugee. Then you apply for leave to appeal under Section 82.3. Every now and then, and sometimes they'll say, we don't find the person to be credible, and we don't find any of his evidence trustworthy. But at the end of the day, if they say, therefore, we determine that the person is not a convention refugee, then you're applying for leave to appeal. But occasionally you'll get a case where they say, not only is this person not a convention refugee, but we find, in addition, we hated this person so much that we find that he doesn't even have a credible basis to his claim. And that's said right at the end of the decision, right? And if they say that, then the provisions, I don't remember, 82.36 or something says, you have no longer have a right to appeal. But of course, you do have a right to apply for judicial review. And in that case, because it's the tribunal now determines where you go, you apply for leave to commence judicial review, but it's in the appeal division pursuant to Section 28, because you're reviewing a decision of the CRDD, which goes to the appeal division, whereas the adjudicator goes to the trial division. Okay? Now, this is all going to change, or it may change when they change the legislation, so that we'll all be totally confused. Because one of the rumors about the changes in the legislation is that everything is going to go to the trial division. But don't worry about that for now. But I mean, just alerting you to the possibility that having changed in February, it's quite possible that it will change again in January. Yeah, that's right. Okay, so now we've decided which tribunal. The second thing we have to do is to figure out when we file the notice of application. We know if it's going to the trial division or the Federal Court of Appeal. We have 15 days. Now, how do we count 15 days? We count 15 days because it's not clear days. We start on the day after the decision was communicated to our client. So if he comes in and says, I got this decision in the mail on Monday. Now, it's very important for us to figure out what communicated to the client means. Now, if it's sent in the mail to the client, the date of the decision may be the 25th. But because your client's moved 4 times, he doesn't get it until 5 or 6 or 7 days later. The day that counts is the day that he or she received the decision or was notified of it. Now, an interesting little twist is, but what happens if it goes to the client's lawyer? Is that notification of the client? Well, there's no jurisprudence on this, and Lee may have comments and Barbara may have comments, but my position is until the client actually knows what's going on, it's not communicated to him or her, and communication to the lawyer is not communication to the client because the lawyer is not yet retained to do the appeal. So, I mean, yeah. Oh, pardon me? Well, why don't you say that?
I think if you are retained to act for the person to proceed in court, and a lot of the legal aid certificates allow you to do that, that notice to the lawyer is notice to the client.
Except that, but I
mean, we went to court on that on contempt against the ministers, that the lawyers were, the Justice Department lawyers were aware and had been served with an order which the minister hadn't complied with. I think you're stretching it too far, and you're taking a lot of chances if you delay as a lawyer giving it to your client and then say, well, we don't count the time till I give it to my client. I think you'd be in a lot of trouble that way. Well, then you don't have instructions to proceed.
Yeah,
Yeah, that may be the case. You're not retained to proceed in that instance. But if you are retained and you know how to contact your client, you can't delay 2 weeks and then count the 15 days.
Oh, sure. That's obviously bad. But I think the problem is what happens if you get this, you get it, and you can't just file a notice of motion. You have to call the client in and get instructions. So does the time run from the day you get it, or 2 days later when your client shows up and you say, I've got bad news for you, here's the decision?
Well, I wouldn't want to take a chance on waiting until the client got notice of it. I think the court could tell you you're out of time.
Okay.
I wouldn't risk it.
All right.
It's not worth it.
So all right, that's fine. I mean, I think that there's obviously a difference of an opinion here. I mean, and I think Barbara's approach is prudent, but I mean, the bottom line is, unless justice, I mean, when you file your notice of motion, you put in it the day that the decision was communicated to the client, okay? And unless justice objects, and I mean, justice may well object, if they see that it's the same lawyer on the appeal and on the notice of motion, they see that 2 months go by at the original hearing, they may say, well, wait a sec, that doesn't make any sense. Obviously, it was sent to the lawyer within a few days. And they may well object But ultimately, the position the courts have taken is because the courts, when they review the notice of motion, they'll look at the time that it says on the notice of motion that it was communicated to the client and count 15 days from there. And as long as it's within the 15 days from the date of communication, they'll accept the notice of motion. Okay, so that then it would be up to justice to object, to say, we do not believe that that's an accurate assessment of the date of that it was actually communicated, because you were the lawyer represented the client at stage 1 and you represented the client at stage 2, and we know that it was sent out by registered mail on such and such a day. So then, so then it becomes a factual question and an interpretation of what that provision means. Now, I don't know. Well, okay, well, we're getting really technical. I don't know of any cases, and maybe Lee can tell me if she knows of anything different, where justice has objected to the date of communication. And well, you can't. Well, I wouldn't do that. How can you file it without contacting them? Lee, hold on, stop. I don't want to have a debate on this point. We got lots of things to cover. We got 1 hour. Go ahead.
Unfortunately, 19.5 CRDD rule seems to say that service is presumed to be effective 7 days after mailing. So if they put it in the mail to the client, 7 days have gone by.
What happens if they mailed it to the wrong address? Yeah.
I think that the position that Justice takes on that is that we do rely on the CRDD rule, that is the 7 days from the date of mailing, and there's nothing in the CRDD rules that says that it has to arrive. The onus is on the applicant to ensure that the board is aware of their address. Certainly, if there became a serious discrepancy between the applicant saying that they did not receive the decision, and the lawyer saying, well, I did receive the decision, but I didn't notify my client, we would probably argue that service on the lawyer constituted service on the client, because the lawyer may or probably was retained, or if the lawyer was retained for the CRDD hearing, certainly the retention, I would suspect, continues through to receiving the decision from the CRDD. To be honest, Justice is not all that scrupulous about counting days from when they presume that the decision has been notified, the claimant has been notified of the decision, unless the time becomes egregious. I mean, we have cases where 4 months after the decision is mailed, there's an argument that the claimant has received it, and at that point we start to look a lot more carefully at the circumstances of serving the decision.
Yeah. Well, I think the bottom line message when you take all of this is to presume service is to not play games with the 15 days and sort of presume that your client receives notice the same time as you and start counting from that day or the next day or whatever, or the day that he receives it. I mean, most of the time it's not a contentious issue. So that now the first point is you have to count the 15 days, and as I said, counting 15 means starting on the day after and counting 15, and then the 15th day is the last day it's due. Okay? So that's important to know, because there's a difference between 15 days and 15 clear days. So when you're filing your application for leave, it's 15 days from the day. You start on the day after your client receives it and count 15 days, and it's due on the 15th day. If the 15th day is a Saturday, a Sunday, or a holiday, it's due on the next day, or the next working day, a Monday. Now, the next important thing to know is they've changed the rules with respect to service. Now, this is a real pain in the neck. What you have to know is that you have to serve the documents on the Department of Justice within the time limit for filing in the court. Okay, so if you have 15 days, you have to file in the court and serve within that 15-day period. Now, the other thing you have to know is that service means personal service, not by fax, by courier. It means personal service. And you have to file proof of service with the court within 5 clear days of the day it's served. Okay, so that start the process. You get 15 days, you file your application for leave. Within that same 15-day period, you must serve personally the Department of Justice. Now, you don't have to serve the tribunals at this stage. You only have to serve the respondent. You don't have to serve the board or the adjudicator. Although it's probably a good idea to do that, and I do, but I don't serve them personally. I serve it by fax or something. But you don't have, and you have to file proof of service within 5 clear days in the federal court. Now the federal court's getting very finicky, so that you have to, they want either, there's 2 types of service to accept. It has to be an affidavit of service saying that the respondent was personally served, or the second possibility is proof of service, which is the acceptance of service stamped on the back of one of the original notices of motion. You can just leave that with the court. So if you send a process servicer down with 2 copies of the notice of motion, justice, someone at the justice signs one and says we've accept service, then you file that copy with the court. That's acceptable proof of service. After you file the notice of the application for leave, you have 30 days, 30 clear days, to file all of your material in support. Okay. Now I'm going to and there are 2 parts to the material in support. The first thing is the affidavits that you file, and this is very interesting. You must file an affidavit. This is the way the rules are drafted. Now sometimes, for example, at credible basis hearings, you'll get the tribunal will prepare the whole transcript. And so you say, well, why do I need an affidavit if I've got the transcript? But you still have to file an affidavit because the federal court immigration rules say the applicant must file an affidavit. So what you do in those circumstances is you file an affidavit saying, I want to rely on the transcript. And then you've complied with the rule and you attach the transcript as an exhibit to the affidavit. And then you've complied with the rule which says that you must file an affidavit setting out the facts. Because some of these lawyers of justice are pretty finicky about these rules. And if you don't comply with the rule, they'll say this application should be dismissed because the lawyer didn't comply with Rule 9, which says you must file an affidavit which sets out the facts to be relied upon. Which, when you've got a transcript, is a bit silly, but that's the way the rules are now drafted. And the other thing you have to file in addition are legal arguments in support. Now, you have to understand this is your client's only chance, and so you have to file a complete factum. One of the justices one day when I was in court, and he said to me, he said, lawyers have to realize that this is, that this is their only chance, and they're under an obligation to file complete factums. I mean, because, we're going to look at these things carefully, and if we don't get satisfactory legal arguments, we're going to dismiss it. So you can't just put a few paragraphs in or file an affidavit without submissions. Nor can you file submissions without an affidavit, because then you've got no factual basis for your case. You have to file both, an affidavit and submissions. Now, what should the affidavit say? Now, if we're talking about a decision at credible basis or in a decision of an adjudicator, one of your big problems is if you don't have the transcript, how do you have the decision? Because you don't have a transcript. At least at the full hearing, you've got the written reasons. What you have to do, unfortunately, I think the only option is to get the tapes from the tribunal and to listen to the tapes and transcribe the decision. You have to do that, because how else can the court make, unless you are counsel. When I'm counsel sometimes, I'll take notes and I can do a more or less verbatim transcription from my notes. And then if I do that, then I don't listen to the tapes. But if I don't have a transcript, and I wasn't counsel representing this person at this credible basis tribunal, how else am I going to satisfy the justice reviewing my leave application that there's an arguable case unless I have put before the justice the reasons for decision, which means I have to transcribe them, which means I have to sit there and listen. Well, again, I don't do it. Someone else does it. But someone has to sit there and listen and transcribe it. And how do you get before the court the evidence that was put before the tribunal? The judge, in order to review these things, needs to know, well, what was said? What was the evidence, So, there's the viva voce evidence of your client. Well, how do you get it before the tribunal if there's no transcript? And this applies at stage 1 or stage 2. The difference between stage 1 and stage 2 is at stage 2 you don't have to transcribe the reasons because you've got them, and you would attach the reasons as an exhibit to the affidavit of your client. But in both cases, you're in a situation where you don't have a transcript and you want the judge to know the evidence that was put forward by your client. Now, in some cases, if you are satisfied that the evidence recited by the board in its reasons for decision is an accurate rendition of the evidence and the issue is a narrow legal point, then you don't have to go through all the trouble of reciting the facts, and you can rely on the facts as found by the tribunal. But in practically every case, the tribunal isn't going to recite all of the relevant facts. In many cases, they may inaccurately cite the facts. I mean, that is one of the main problems we have with decisions. But how does the judge know that the facts, as recited by the tribunal, are inaccurate, unless you put that before the judge in an affidavit? I mean, obviously, the best way to do it would be a transcript. And Barbara said that sometimes she has the actual transcript transcribed. I mean, the transcript transcribed. But I mean, do you do that sometimes?
We do it in almost every case. It's very rare that we would not take the tapes and have someone in our office transcribe them. In particular, where we weren't counsel of record in the first hearing. Because I mean, you don't know what the evidence was unless you go through those tapes, and it's easier for the court and for everyone involved if you have the tapes transcribed.
Well,
and legal aid does cover that. You just have to.
Well, I don't. I mean, I don't.
You're doing it.
Well, I don't do that. What I do is I listen to the tapes, and as I listen to the tapes, I do an affidavit in which I set out the evidence.
But then you can't argue your own.
No, but I don't. I have the affidavit put in my client's name. I put an affidavit in which my client says my evidence was ABC, which is the evidence he gave.
Right.
And I say in the affidavit, I say this my recollection has been refreshed by my counsel's review of the tapes, and I confirm that this is an accurate rendition of all the evidence I gave. And I mean, I suppose, I mean, Barbara's approach is the ideal approach, is to get the transcript done in every case, because it's the only I mean, it's the only way in which the court is going to really know what transpired. And if there are key evidentiary points that are in dispute, the court needs to know. I mean, but whether you have a transcript done or you do an affidavit, you have to do something to get that evidence before the court. And each lawyer will have to decide what the most effective way of doing it. I haven't yet gone to the point of doing, I will sometimes, what I do is there'll be key sections of the evidence that I will transcribe verbatim. In other words, where there's something critical, where I think the board has made some, you know, and I'll transcribe those, and then the rest I'll do by way of summary in the affidavit. But in any event, however you do it, if you want the facts to be before the court, you have to put them before the court, because there's no transcript given. And the way you do that is by affidavit, and either you transcribe the whole tapes and then you attach the transcription as an affidavit, or you do an affidavit in which you summarize the evidence that was given by the tribunal. I think justice would probably prefer a transcript, but I mean, then they're going to get stuck with the transcript that we've done as opposed to the official court transcript. But there's really no way around that at the leave stage, because there is usually not a transcript prepared.
But just one other thing about this point, because it's important. You should always check, like if you're taking over a case, or even if it's your own case, check with the adjudication office if it's credible basis, and the refugee division, to see if they're going to make a transcript. Because often they will have sent out the tapes to have a transcript made, and then you don't need to ask for the tapes. Instead, you can ask for an extension of time from the federal court, because you know the transcript's coming. So you tell the federal court, you find out when it's likely to arrive, and if it's beyond your 30 days, make an application to the court saying, they've advised us this transcript's being prepared, it should be ready by such and such a date, can we have 10 days beyond that, or 20 days beyond that, to do the factum? To put material before the court and do the memorandum of fact and law. But check, because half the time they have in fact ordered the transcript.
Okay. But then the next point is, having got your client's evidence and any other viva voce evidence, you have to ensure that the court also knows the documentary evidence that was put before the tribunal. Now, when you make an application for leave, you also make a Rule 23, whatever it is, a request to the tribunal to forward all of the like in your application for leave, one of the things that it says in the precedent is, we request that the tribunal send a copy of all the exhibits filed at the hearing. And if you send that, that's why you have to send that to the tribunal. You'll send a copy of that to the tribunal, and then the tribunal will, as a matter of course, forward the exhibits to the court. Okay, so they're in the court file for that case, but they're not with justice. So to be nice to justice, what you do is you attach the exhibits as an exhibit to the affidavit, although some lawyers, like, I don't think Barbara does, but I normally do. I just attach the exhibits. So I know for sure, in case the tribunal messed up and doesn't send the documents to the court, that the court has the documentary evidence that was before it. Because if you're relying on the documentary evidence, it has to be part of the record on the leave application. So the most difficult part in the leave application, in a lot of cases, is creating the record for the court to be able to reach a decision, because you don't have a transcript, the court doesn't have anything, and it's up to the lawyer who is applying for leave to prepare the record that goes before the court. And that's why some of the justice lawyers who act as applicants sometimes say, gee, once we've acted as applicant, we realize how much more difficult it is, because it's on the applicant to file the material, the onus. Okay, then you get to your memorandum, and obviously, as I said, I don't know what more I can say about it, except that you have to cite the relevant case law. I mean, all the things we said in terms of the opinion letter. It's very important that you put before the court all of the legal arguments that you're relying on. Don't be afraid to rely on natural justice arguments. I mean, the court likes natural justice arguments. The tribunal often makes natural justice-y type mistakes. And to give you an example of what I'm doing now, I love it. The board looks like it has on word processor the first 3 paragraphs of the decision. On such and such a day we heard such and such a claim, and they just fill in the blanks, and we filed the standardized country profile index and advised counsel that it would be an exhibit. And then in this one particular case they said that, and then they relied on the standardized country file in their decision, but of course what they didn't remember or whatever is that they hadn't filed the index. So they said they had, but they didn't. So I think that there's a recent case called Paniagua-Aquino, in which the federal court said if they don't take something into evidence, they can't rely on it. Well, if they haven't even, one interesting question is whether taking the index of a standardized country file takes the whole standardized country file into evidence, which is one of my pet peeves. But independently of that, I've been accused of being an anti-environmentalist because my position would mean that the board would have to file all of the documents in every case. Well, my response is that what it would mean is the board would have to think what is relevant and not just file this index as an excuse for putting documentary evidence before them. But in any event, in this particular case, the board didn't even file the index. So it was clearly not, if you want to argue or not whether the index puts the documents before the court, if they don't even file the index, how can they argue that? So, I mean, that's a nice neat little point, which I think will win the appeal for my client. And so look for those types of issues. If you're raising, definitional issues, look for those issues too. Well, then after you've filed your factum with the court, Justice gets it, and be sure to serve it on Justice within the same 30-day period. And it doesn't have, yes, it has to be personal service, because Justice has not yet appeared on the record as the respondent, and so you have to serve them personally.
If I could add to that, that's a position taken by the federal court. That's not the position taken by Justice.
Okay, well, I just asked the federal court this yesterday.
That's
but
right.
They don't require, in any event, so then, and you have to file proof of service on the court within 5 days of the fact that you've served Justice. And after that, Justice gets these papers, and they have 20 days now to file their response, their submissions. Now, Justice can file affidavits and can file submissions, and then you will receive these in the mail, but you can be served by fax because you are already on the record, and once you've appeared on the record, so in most cases, in fact, Justice will fax you their submissions. And it's important to note that service by fax is effected the same day you receive it, or it's sent, so that you then have 10 clear days from the date of the receipt of submissions to file your reply. Now, one piece of warning, I don't know how true this is, but I've heard this apocryphal story from a lawyer who claims to have spoken to some justice in the federal court and claims to have heard this justice say that in cases where lawyers do not file replies, the appeals are automatically dismissed because the position the court will take is that the lawyer has not, the applicant's lawyer hasn't answered the submissions of the respondent. Now, I don't know how true that is, but I mean, it's a rumor anyway. But in any event,
It's more than a rumor. I thought Mr. Justice McGuigan said it to Mendel Green's class.
Okay, well,
that you have to reply.
I was trying to be discreet, Barbara.
I don't think there's anything discreet about it. If that's the standard they're using, tell people.
Well,
And it
anyway,
was
what I
Mr.
was going to
Justice
say is,
McGuigan that
regardless
said
regardless of who said it when. I mean, apparently, Mr. Justice McGuigan said it in Mendel Green's immigration law class at the University of London on May, no, but, and it's all recorded. No, but in any event, regardless of that, it certainly is a good idea to make a reply, and I always do it in every case. I mean, if only you say, I disagree with everything the respondent says, I think it's a crock and it's all wrong and they've misstated the law, at least you put your position down so the court knows that you don't accept the respondent's admissions. And you have 10 days to file those. And then after that, this case goes into this black hole called the court backlog. And then you're sitting there in your office someday working on something else, and you get this call, and your secretary comes in, it's the federal court in Ottawa. And then you'll say yes, and you'll pick up the phone, and someone in Ottawa says, yes, this is the federal court calling. I'm calling on file 92-A-1476. And you'll say, oh, what 1476? And you'll say, can I please have the client's name? And they'll say, yes. And so I always say, well, I always ask right off the top, who is the justice who asked for the decision before they give it, you know. So I say, and they say, Justice so-and-so, and then I know already whether I'm going to get it or not. That's not exactly true, but I know what the odds are, you know. And then then you'll get communicated the leave. Now, if you've got leave, if you haven't got leave, well, that's it, you know. You call your client in and you say, I did my best and I'm sorry. But if you get leave at that point, you have to be very careful to note the day of the order, okay? And they'll tell you that. And the problem is that the federal court is so backlogged that they often will not send you the order for I got an order last week that was 4 months ago. So, I mean, if you wait until you get the order to file your notice of appeal, you're in big trouble. So that the day of the order, you have 15 days to file your application, your notice of appeal, if it's from a CRDD, or your application for judicial review, if it's from an adjudicator, or if it's a finding of no credible basis. Okay, now here's where the rules diverge, and this is all new. If it's a leave to appeal, you file your leave to appeal, and notice of appeal and you have to serve it now. But now you have to serve it, just to make things complicated, the rules for service are different now, okay? Because you have to serve it on justice, but you also have to serve it on the board, because you have to serve it on all the interested parties. So that would be the justice and the board. Okay, and then if it's a notice of appeal at that point, and you have to file proof of service. I don't think there's a set time period within which you have to file it, but I would do it as quickly as possible. Then now, under the new rules, the board then prepares the transcript and sends requisite numbers of copies of the transcript to the court, and also sends one copy to the lawyer and one copy to the respondent. And then you have 3 weeks within which to file your factum and your record based upon it.
60 days.
No.
On appeals?
On appeals. I've got it. Appeals is 3 weeks, right? All right, wait a second. This is very complicated here. I got to check. This is all new.
I'll check it.
All right, it doesn't matter. You've got a certain number of time, and you have to file everything within that time. Now, Barbara's checking how much time right now, so I don't take up too much time here. It's because this is the appeal stage. I thought it was 3 weeks, but I may be wrong. And so you have to file. You see, the way it used to be is you filed your notice of appeal, and then it went into a black hole. And you had to wait. You waited till these nice yellow case books came, and they were prepared by the Court of Appeal, and they would take a year to come to you, and then you would have 3 weeks to file your factum. And then the other interesting thing was, of course, because the court couldn't set things down on appeals, but they had to wait till both parties set them down. I mean, some of these appeals would sit for 3, 4, 5, 10, 15 years and never get argued. Now the court has changed the rules, and they can set down an appeal after the time limit for filing the record has passed. So it means we no longer ignore these. And a lot of people on the week of May 25th had a rather rude awakening, because in Toronto the court said 15 appeals down with 2 weeks notice. And I had 3. And so all of a sudden, Zappo, the court is now setting these things down. So if you let them sit in your filing cabinet, you're going to have a lot of trouble, because all of a sudden you're going to get this order from the court, your appeals being heard next Monday, and you're going to have a week to get everything together. So it's not a good idea anymore to leave your file sitting around. Then, in the case of applications so basically with respect to appeals, you have to file the notice of appeal, serve it, you wait for the tribunal to serve you with a copy of the transcript, and then when you receive the transcript, you have a period of time, which Barbara's going to now tell us how much you did. 3 weeks.
Receiving the material from the tribunal.
See, I was right. See, I told you. That's it. What's number? Which rule is it? Rule
1307.
1307 says, that's the rule. It says memorandum, and it says, oh, all right. Well, it says 3 weeks or such longer period as the interested persons agree or the court orders after receiving a copy of the material in the case from the tribunal. Okay. Yeah, except the difference now is that the tribunal prepares the record and sends it to you, as opposed to the way it was before, where the tribunal sent it to the court then put it in the case books, and the case books send it to you. Yeah. No.
The tribunal does.
No. That's the difference. Under the new rules, the court doesn't prepare the case anymore at all. Under the new rules, the tribunal prepares the record, sends it to the parties in the requisite number of copies, and then you file the memorandum within 3 weeks of receiving the record.
The record.
Not from the court, from the tribunal now. That's the difference.
Yeah, no, it says that specifically here.
1300 rules, yeah. Pardon me? February 1st. Well, okay.
No, look, they're all messed up on this. First of all, I'm not sure they know they're supposed to be preparing the record, but you might have to send them a letter, quote the rule to them, and tell them it's their obligation to prepare it. Once it's prepared, you get it, then you have 3 weeks.
Yeah.
Adjudication, at least at the backlog office, is refusing to comply with the rule. They put in, one of the adjudicators in one of my cases put in a letter to the court objecting under Rule 1603 or something that it was going to take too much time to copy everything. So therefore he wasn't going to provide it.
Okay. All right. Well, well, in any event, I mean, that's true, because I just had to write this rather nasty letter to the board this week, because I have, all right, so hold on, I'll tell you in the context. So in the case of appeals, what happens is, when you file your notice of appeal, the tribunal has to prepare the transcript, sends the transcript to the requisite, it's 5 copies to the court, 1 copy to justice, and 1 copy to us. Then we prepare our factum within 3 weeks, and that's the way it goes. And in the case of an application for judicial review, be it finding of no credible basis from a credible basis, that would be in the appeal division, or an application for judicial review to review a decision of an adjudicator in the trial division, in either case, if it's an application for judicial review, the applicant must prepare the record within 60 days. Okay. And the rules state specifically what the record must have, and it says it has to have a table of contents. It's all in my paper here. It says a table of contents. It has to have the original notice of motion, the affidavit to be affidavit relied upon, and the transcript, any exhibits, and the applicant's submissions. Okay, but there's a trick. There's one little trick that I've just realized that's causing me no end of grief. The rules state if it's an application for judicial review and you get the order from the court granting you leave, within 15 days you have to file the originating notice asking for judicial review pursuant to section 18.1 or section 28. The rule says that when you file your originating notice, you have to file affidavit which set out the facts. Now, the registry, at least, is interpreting the rules to say that you can only file in your record the affidavits that you file at the time you file the originating notice. So let's go through this again. You get the order from the court. Yes, you've got leave to commence judicial review to review the decision of the adjudicator that found and board member that found your client had no credible basis. Okay? So that means you have 15 days to file your application for judicial review pursuant to Section 18.1. But what you have to also remember is the rules require that at the time you file your application for judicial review, you must file the affidavits you tend to rely on. Okay. Now, this is actually quite interesting, and some of the lawyers in justice are not very pleased with this, because what it means is that you can file affidavits, and you can put in the affidavits anything you like. You know, the adjudicator is a fashion. I don't know, whatever you want, and then, you know, and because the rule doesn't restrict what you can put in that affidavit, then it puts the onus on justice to object, and there's really no criteria. But in any event, whatever you want to put before the court, you have to put it before the court at the time you file the originating notice. I'll be finished in 2 minutes, and then we'll get Lee, then we'll take some questions, then we'll do Barbara, and then we'll take some questions. And no, we're not going to have a break. We don't have time for a break. Well, go have your cigarette now. All right. We're just having a discussion. Barbara wants a break, but we don't have time. So that at the time you file the application for judicial review, you have to file the affidavits. Now, I'm not exactly sure if the registry is right when they say all of the affidavits, but I think it's probably prudent to put it all in at that point. Now, there's one other trick, which is if you can ask the registry to transfer the affidavits that you relied on your leave application so that they become part of the main application for judicial review. And if that's the case, you don't have to file new affidavits unless you want to. So you get the leave, you file the originating notice, you serve it within 15 days, you file the affidavits at the same time. From the date you file your originating notice and your affidavit, you have 60 days to file your applicant's record. And that has to include the originating notice, the affidavits, the transcript, if any, the exhibits, if any, plus your factum. So you'll have 60 days to do that.
But what if you don't, I mean, if you're relying on we've had this problem, you're relying on a transcript, you don't want to put in an affidavit, the federal court won't take your notice unless you put in the affidavit. So we've been putting in an affidavit saying this is to confirm that we don't intend to rely on an affidavit.
Yeah, that's right. That's what.
And then they're satisfied.
Yeah.
No, they won't let you.
You
The
have to have an
registry
affidavit
won't
with it.
let you. They say it says shall file an affidavit.
Yeah, you have to have an affidavit.
So in order to get around them,
No.
the rule is really unclear. It probably needs to go up to the court for directions, but it says at the time of filing the notice of motion, the applicant shall also file one or more affidavits.
That's 50.
Yeah, but that's a different issue. If you want it transferred, you can do that. No. If you don't, you can get it transferred up. They'll accept that. But if you don't want it transferred up, and instead you just want to rely on the transcript of the credible basis hearing, you don't want to rely on an affidavit. We've been putting in an affidavit saying we're relying on the transcript.
That's
We
right.
are not relying on an affidavit.
But that's very important. But don't forget that applies at the time you file the originating notice under Section 18.1 or 28. But it also applies when your application for leave, because if you don't file an affidavit, you haven't complied with the requirements of the federal court immigration rules, and some smart justice lawyer is going to say this application should be dismissed because there's no affidavit, even though the transcript is sitting there, right? And she's going to say we would never do that, but I can tell you that some of them have. So
Actually, I wouldn't tell you that.
you wouldn't tell me that, eh? Okay, we're almost done. I guess that's everything I have to say on federal court procedure. Then now, as I said, under the new rules, after you've filed your affidavit, they've got 30 days. If it's an appeal, they have 3 weeks to file their response. And if it's a application for judicial review, they have 30 days to file their record. In any event, then after that, the court, there are two possibilities. You can apply to the court on a joint application to set it down if you're really in a hurry to have it heard, or else you can wait till the court sets it down of its own volition. The court will do that now and has the power to do that. So that's all I want to say on federal court practice, and Lee is going to make some comments.
Let me know if you can't hear me because my voice is quite low. When Lorne asked me to do this, I said to him, what do you want me to talk about? And he said, well, you tell me what justice says we're doing wrong. So that's essentially what the focus is. Obviously, as As Lorne has indicated, we do tend to look at the rules a lot, and if there are procedural difficulties and technical difficulties with your material, we will bring applications to strike, or we will call you and tell you we insist that you amend before we're prepared to proceed. And we'll continue to rely on what you would perceive as technical deficiencies to strike your material. This isn't necessarily because we don't feel it's worth getting to the merits of your case, but the rules were put there for a purpose, and as far as we're concerned, it's for the court's benefit and it's for your client's benefit if you comply with the rules. And that's primarily the reason that we do it. I can't stress to you enough the importance of reading the two acts that govern immigration law. You must know the Immigration Act, and you must know the Federal Court Rules and the Federal Court Act. Those determine everything that you do, and they're interrelated. You can't simply rely on the Federal Court Act, which says that I have 30 days to do this and 40 days to do that, without first looking at the Immigration Act, which tells you where you begin. And we have more problems with people applying for extension of time because they assume that the Federal Court Rules governed the Immigration Act, when in fact it was the Immigration Act which governed the filing of the notice of application for leave, et cetera, et cetera. A typical problem that we run into every year is at the Christmas long vacation. The Christmas long vacation applies only to the Federal Court Rules. It does not apply to the Immigration Act, so if you're commencing your application for leave, you must abide by the Immigration Act, which says 15 days from the date of decision, has nothing to do with the fact that it's Christmas Day. It's only when you get into the Federal Court Rules that long vacation and Christmas vacation rules apply. So be very, very familiar with the two acts. Don't confuse the two acts, and realize that certain jurisdiction comes from the Immigration Act and certain jurisdiction comes from the Federal Court Act. The other thing I should say about that is that the Federal Court Act and rules particularly are changing on a practically daily basis. So it's no good to say, well, I knew this used to happen like this, because it doesn't anymore. We have a situation now in the court where we're applying for reconsideration of an order granting leave where we weren't served with the notice of motion and affidavit, or the application for leave and affidavit. And the lawyer in response said, well, the court's supposed to serve. And our response was, no, that changed on November 1st. You're responsible for serving us. So please reread your rules on a very regular basis. Be familiar with the changes to the rules and to the regulations, because they're very important. Also, although this isn't probably very legitimate, the court registry itself interprets the rules in a variety of ways, which may not necessarily accord with your reading of the rules. So it's important to talk to the registry and the registry officers to make sure that you're doing what they want you to do, so they'll accept your documents. The classic example of that, and I've been asked to draw it to your attention, is with regard to filing your notices of motion, originating notices of motion for judicial review when you've been granted leave. The rules and the forms are set out in one particular way. In fact, the registry is requiring two further pieces of information from you in your applications for judicial review, and that is, you should say, originating notice of motion pursuant to the section you're relying on, not simply originating notice of motion as it says in your form. And secondly, if you're requesting information, requesting that the affidavits filed on the leave are transferred to your application for judicial review, you have to include that in your notice of motion. So, so it does pay, first of all, to check with the court and make sure you're doing it right. Secondly, if you have time, do it 2 or 3 days early so that they can reject your documents and you have time to try again. All right? When I'm saying this, I'm speaking from personal experience, so I'm not suggesting that we don't have the same problems that you do. The primary area I think that members of the bar run into, as far as we're concerned, is with respect to filing affidavits and affidavit material. The rules in respect of affidavit materials, it's Rule 332 of the Federal Court Rules, and you should reread it and reread it and reread it, because countless errors are made, and we will, in most cases, we will bring these to the attention of the court, and in some cases we will attempt to have them struck altogether. First of all, you have to file an affidavit. You cannot not file an affidavit. And Lorne has said, justice lawyers are going to ask to have it dismissed. You're right, justice lawyers will ask to have it dismissed. If we don't ask it to have it dismissed, the court will dismiss it of its own volition. The court will not grant leave when you have not filed an affidavit. So that's the bottom line. You don't have to worry about us being an intermediary.
But there's one other point I forgot to mention, and I'll interject now, and maybe we can comment, and that is that the rules state that in the application for leave, you have to name the persons, the affidavits, the deponents of the affidavits you're going to file. So this creates a problem. I mean, so what I now do is I have on my word processor, in my application for leave, I put 15 people down. I put every possible person in my office who might happen to listen to the tapes. Because what's happened to me once, and fortunately it wasn't a total disaster, but is that the person who listened to the tapes was not one of the persons listed in my affidavit. And, and then you get yourself into this really difficult situation where someone's gone to all this work of listening to the tapes. And I didn't even, and if you don't catch it, I mean, so when you file your application for leave, you have to list the affidavits that you're going to rely on. So my advice to you is make sure you have at least an affidavit of A, B, C, D, E, F, and G, so that gives you a certain amount of flexibility as to who's going to file an affidavit. Because I mean, if you don't file an affidavit from one of the person listed, there's no problem. But if you try to file it from someone who's not on your list, there may be a problem. And I don't know what the court will do with that, but I've had justice lawyers object when I filed an affidavit from A when he wasn't on the list.
You don't. We stop naming people. Yeah, we stop naming people for that reason. We just say that the affidavit that we will be filing.
Does someone have the rules here? I'd like to look at that for a second, because I think. Yeah, okay. Is that what it's got the stuff in it? Yeah, I've got the update. Well, okay. Well, you continue, Lee. Well, I check that.
Yes, absolutely. If we note that an interpreter has been used on the with filing the PIF, and if we note that that an interpreter was present at the hearing, I will always indicate that no affidavit of interpretation was filed with the affidavit, and the affidavit should be struck or disregarded. Now, you may say, well, we didn't need an affidavit, an interpreter, and we didn't use an interpreter. My suggestion is that you indicate in the affidavit that you did not require an interpreter, because certainly, I mean, I have no information as to whether or not an interpreter was there. The only thing I could suppose is that if you needed an interpreter 2 months earlier, you probably needed an interpreter now, and I'm going to put that in. So yes, as far as I'm concerned at least, and I think most of my colleagues do the same, we look very carefully at that, and we will make submissions on that point. So it is crucial, as far as I'm concerned, to file an affidavit of an interpreter.
Well, I think the question was if you have to list the names of the people in the application for leave, do you have to list the name of the interpreter? And I think that my position would be, in other words, if you don't list the name of the interpreter, it's not a problem, because he's just the person who's certifying that the deponent, who is your client, understood the contents of the affidavit.
I would agree with that, but don't disregard my point. That is, if you use an interpreter, or if you have used an interpreter, please file the affidavit of translation, and that is frequently forgotten. Mm-hmm.
I can no longer file affidavit, evidence, or at that stage.
Well,
How would
I think that your alternative at that point is to bring a notice of motion to file further material.
324.
That's what I would suggest. Now, that's one of the reasons that we're here today, to tell you, why don't you avoid these pitfalls? It's not all that difficult in many cases. Okay.
Well, okay, I think that just to go back, Rule 8 says that in your notice of motion, you have to list each affidavit to be used in support of the application for leave. Now, I don't know if that means you have to give a specific name of a deponent or not. I mean, I take one approach, and my approach is to name everybody in my office. That's what I do. And the applicant. And the applicant's mother, brother, and sister, too. But, I mean, Barbara's approach is just to say in affidavits, and I don't know what justice would.
We haven't had the federal court stop us. We stop naming people because you end up with one secretary transcribing when you thought it was going to be another secretary. You can't put in the affidavit from the secretary you named, and you don't really know it ahead of time. So I just stopped putting in names of people.
But I know that
But the
justice
court
will
hasn't
object.
stopped it.
Justice will object if you put an affidavit from someone who isn't listed. if you've listed some people and you haven't, I mean, if you say A, B, and C, and then you put an affidavit in for D, some of the lawyers from Justice have objected and said that person wasn't listed. So if you're going to list, make sure you have a broad list. And if you want, and you can, I suppose, take Barbara's approach until proven otherwise. What is your position on that?
My personal position is that I don't read it, so that I would not even notice, to be honest with you, if you hadn't put in the list. And I almost certainly would not object. That's not, as Lorne has indicated, that's not necessarily the position of everybody at Justice. There's a variety. To answer the point that you've made about being over-technical, I realize that that is the perception in the bar. We get accused of that all the time. I get people who are practically hysterical on the phone yelling at me, how can you do this, how can you do this, you're wasting everybody's time. I'm not at this point going to defend my actions. I'm going to say all I can tell you is that this is the position we take, and we will continue to take this position, so that I think at this point, while I'm going through this, it's probably a waste of your time to attack me for doing it, okay? I'm sorry. If I can continue, another problem with affidavits that we run into.
That was very good. I need to give it.
Okay.
It's 3:45 on Friday, and that was very good. I like that. Left them on the floor there.
Sorry, is that we frequently run into people acting as both counsel and witness. That is, they sign the notice of motion or they sign the application for leave, and then they swear the affidavit. Again, unless it's an oversight on our part, and it will be an oversight only, we will move to strike your affidavit. Okay. The rules are very clear. You don't even have to read that much, and you'll find that answer. Counsel will often sign the application for leave or a notice of motion, and this is equally true with motions for extension of time or other purposes, and they will then swear the affidavit in support. And unless, as I say, unless it's an oversight on our part, it is our position that you are not counsel and witness, and you must, and we will move to strike your affidavit. So that get someone else to sign your notice of motion. We routinely do that. Or alternatively, get someone else to swear your affidavit. But you can't do both. And we're particularly sensitive to that when you sign the application for leave, and then when you purport to give evidence in support of the application for leave on the substantive matters in your case. I was at the hearing and I heard this, and I was at the hearing and I heard that. We're very, very, we very don't like that, and we will object, always.
Well, you object if you sign the notice of motion and then you sign the affidavit, is that what you're saying?
That's right.
Yeah.
Because you're appearing as counsel and witness. Well, then it also becomes an issue of who's signing your submissions, doesn't it? I mean, as long as you're appearing as counsel and witness, as far as we're concerned, the rules prohibit it. You can also, and I mean, these are all clear in the rules, on an application for leave, you can't sign an affidavit on information and belief. So that if on your application for leave, you're putting in the substantive issues, and most of us are not that technical in terms of, well, I'm attaching an affidavit, but if you start testifying as to the substantive matters on which you're relying on information and belief, that is, my client told me that this happened to him, my client told me that this happened to him, again, we will probably, we will certainly mention it in our memorandum of fact and law, and we will ask the judge to disregard the affidavit, because again, that's specifically forbidden by the rules. It has to be on this is not with respect to notices of motion or interlocutory matters, but on applications for leave, the rules are quite clear, you don't do that, and we will rely on that technicality. And as I've indicated before, affidavits of translation, we need them. Yes? I'm sorry, what are you talking about? Yes. My information on this is that certainly if the decision was rendered prior to the change in the rules, and if the notice of motion was filed prior to the change in the rules, the court is still serving us with the yellow books. My information was, and Barbara has corrected this, my information was that on applications, appeals, the court was still preparing yellow books, but I bow to Barbara's knowledge. I cannot confirm that for sure. No, 1300 still applies with respect to appeals.
But it's in there. It says the tribunal prepares the record and sends copies to all the parties. It doesn't say the court prepares it. Appeals.
Appeals.
Statutory appeals. Well, it doesn't matter who gives it to you. Your 3 weeks count from the time you get it.
Okay, the only thing I can tell you about this is that, as I said, if your notice of appeal was filed prior to February 1st, 1992, I know for a fact the court is still preparing the record. If you file your notice of appeal subsequent to February 1st, 1992, and you want to be sure, call the court, because obviously there's a difference of opinion here. And it's-
No, you can't either. The case law says you can't do that.
It's Rule 332 and the case law under Rule 332.
It's the case law, I think, more explicitly than the rule.
In terms of your affidavit material, I know Lorne has said that it's important to get the entire record before the court, and he's absolutely correct. Justice appreciates very much if you attach to your affidavit material the reasons for decision of the CRDD and the PIF. I think that it goes to justice, but more importantly, it goes to the court, and at least then you're guaranteed that the record is before the court, because in a lot of cases, I don't think it is unless you put it there. It's important that you put it there. In terms of the documentary evidence, you may not wish to file 1,200 pages of the standardized country file, but it's certainly useful to file the material that you're relying on so the judges can read the standardized, part of the standardized country file and your own material that you're relying on. It's also, I find, important that if you did file special exhibits at the CRDD hearing, that you attach those also to your affidavits, or if you're filing things like arrest warrants, that kind of thing. The best way to ensure it's before the court is to put it there yourself.
What if you rely on tapes in your affidavit? You then have to attach the tapes.
Well, if you're indicating that the tapes are attached as an exhibit, then yes, you have to file the tapes. But if you don't indicate that you're simply filing a transcription, then no. Now, in terms of transcripts, obviously they're the best evidence that you have. The one thing that the justice will object to is if you file selected portions of the transcript. And it appears quite clear that you've only attached those selected, or appears to us that the only portions you've attached are the portions that are beneficial to you. So be somewhat careful about that. If there are large sections of ... you can be sure we'll look into it a little carefully. Now, in terms of service, as Lorne has indicated, you do serve us. If you want the tribunal to send the record, you have to serve the tribunal. The tribunal will not send the record unless you serve them with the notice of motion or your application for leave. And this is particularly important at the 82.1 stage, because if you want a transcript, Judy Algar at Backlog particularly will make arrangements to type the transcript. If they're served with their notice of application for leave, they won't do it until they know that you want it. But
They won't do it for us. Maybe they'll do it if you ask them.
well, people tell us that they'll do it for us. That's not true either. They are an independent body. Apparently, the practice is if you serve them with your notice of application for leave indicating that you want a copy of the transcript, they will commence to prepare the transcript. They won't do it unless you serve them.
No, but that's not true. I mean, or at least maybe they're telling us something different than they're telling you guys. But at Toronto Backlog, they leave it up to each adjudicator. And if the adjudicator sends out to get the transcript prepared, it'll be prepared, whether you serve them or not. If the adjudicator decides not to, and some of the adjudicators won't ever get you a transcript. One of the ones we're having a fight with, we got leave. We filed the notice, and the adjudicator still doesn't want to provide it. So it depends on the individual adjudicator.
Yeah.
Mm-hmm. Okay.
This-
Well, that's true. Yeah,
Well-
that happens.
Well,
No, but they're not going to leave you out in the lurch. I mean, if you're waiting for a transcript, I've never known the court to refuse the extension of time. No, I know, but
long as you
if it's
file
over
within
the
the
30
time.
days, the court's not going to give you an order saying you're out of time. They're going to give you an order at least giving you a little bit of time to send it in, I think.
The court's not going to dismiss it if you filed a notice of motion to extend the time with it. That's one thing I wanted to say, one really important point. You've got 30 days, okay? The federal court is a very efficient registry office. On the 31st day, your file is BF'd, and if there's nothing filed, there's a little red flag, and they go bing, 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 and they say, oh, great, one file we can get rid of right away. And it's up on and it can be up on the Justice's office on the 31st day. And then if the Justice says, and what'll happen is the Justice looks at that, opens the file, and there's nothing inside except the application for leave, Justice says, oh, great, and he signs an order saying the applicant not having filed any materials in support of this application, the application for leave is dismissed. Now, once that order is signed and sealed and delivered, you're kaput, right? You can file a 1733 to vary, but the way the court has been on those, I mean, we've had counsel filing saying that the claimant didn't even know that his lawyer filed it, and he didn't have and the lawyer didn't have authorization, and if he would have, he wouldn't have given it to him, and he wanted this other lawyer to do it, and the court still has refused to vary the order. So once that order is signed, saying dismissed, it's dismissed. I mean, I'm not saying that they will never do it, but there was a fairly progressive case called SAWAC where they seemed to indicate that they might be willing to reconsider, but now
They did reconsider. They
In
didn't just say
SAWAC.
they might,
Yeah, well, they did in SAWAC, but they've retrenched from that position considerably in the most recent decisions. So if you know that you're going to be out of time, don't wait till the 31st day to file your application for extension of time. File it on the 29th, because then you've told the court that you're still interested in proceeding with this appeal. And then the worst that will happen is even if the court is not inclined to grant you an extension, they'll grant you a peremptory extension to file, which will give you enough time. I mean, you may have to stay up all night, but you'll have at least some time to file something, right?
That's right.
They'll never say, application dismissed, you have no more time. What they'll say, if you file an extension on the 29th day, and it gets up to a justice, the worst that will happen is that he'll say, application dismissed, counsel must file peremptorily by next Friday, or something like that. But they'll give you some time. They won't dismiss an application where you filed your application for an extension within the time period. Okay, we're running out of time. Barbara's got to do stays.
But I don't think Lee's even finished. Would you let her finish?
Oh.
A couple of more points, and I'll try and be brief. First of all, as Lorne has said, there is an obligation to file and serve within the time frame. We're getting more and more situations where you're filing on one day and waiting 2 or 3 days to serve us. Although we haven't done anything yet, there's a recent case decision by Justice Kerr. It's only about a week old, and it says that your material filed is a nullity if you don't serve us, so don't just hang around. I mean, if you're at the court at 5 to 5, you better make sure your fax is operating because you have to serve us that day. In terms of judicial review, this is the area where we're having the most problems right now, not only in terms of materials coming to us, but on our own behalf. The rules have changed, and they've changed significantly. I can only suggest that you read them extremely carefully and that you comply with them. Realize that only a judge can vary the provisions in those rules, so you can't come to us and say, I missed my time for filing my factum, or I missed my time for doing this, can you help me? We may be more than happy to do it, but we can't do it without the consent of the judge. So what I'm doing now is reading them because I've missed a couple of time deadlines myself, and I suggest that you be very careful on your judicial review applications because the potential for disaster is very great, I would say. One last point, when you serve us with your submissions, please include your telephone number and your fax number. The court really likes it, and we really like to know how to get hold of you to serve documents. And we've received calls from the court saying, please tell us how to get hold of this counsel, it's really important, and they didn't let us know, and we don't know either, because sometimes you're not in the lawyer's directory, sometimes we can't find out where you are or how to reach you, and to be honest, we don't spend a whole lot of time doing it. So please, please make sure your fax contains a phone number. Your materials contain at least a phone number. Thank you.
Okay, I'm supposed to be talking about stays, and like Lorne said, I actually have almost finished the paper, which I wasn't even asked to do, by the way. So, but I just figured the case law around when you give a stay or not give a stay is so messed up that it would be more helpful to reduce it to writing in terms of where the court's at in it. One of the problems with the case law around injunctive relief in the federal court is that, like the refugee division, the federal court tends only to write reasons when they say no. And the number of cases where stays have been granted that are on good grounds, you won't find any reasons written for it. So often you end up relying on orders of the court without reasons, where you know the factual background of the case and you heard about it by word of mouth from another lawyer. It's a problem, and I think the federal court, it's fair to say, has been derelict in its duty to ensure that there is an adequate body of written precedent dealing with this issue that puts fairly to the public the positions that go both ways, not just the restrictive positions. In terms of, I'm going to cover the jurisdiction of the court and then the test for a stay. In terms of the jurisdiction of the court, there were two issues that sort of, one of them seems to be resolved, the other isn't. One is whether the court can give leave, can give a stay before leave is granted. Mr. Justice Marceau and Batia had indicated when the legislation was first changed that he didn't think the court had jurisdiction to grant a stay against a removal order if leave hadn't been considered yet by the court. That appears to be resolved in that most judges will give leave, will give stays if they're prepared to give one before leave is granted, and there are maybe not reasons, but there are at least orders which make it clear that leave hasn't been granted and a stay was given. One of those cases where that was done is Muhammad Ali. It was Mr. Justice Iacobucci who indicated the stay would go, although leave had not yet been considered by the court. The second issue is whether you can get, whether the court has jurisdiction to give a stay where the deportation order itself is not being challenged, where the validity of the order is not an issue. I thought that issue had been resolved because the federal court justices were in fact giving stays in instances where the validity of the order was not being attacked by the person before the court. However, the Federal Court of Appeal in a case called Akiampong, which came out March 27th, 1992, Mr. Justice Hugeson, for a panel of 3 judges, says that the deportation order wasn't directly attacked in the notice of motion, allowed counsel to amend in order to make a direct attack on the deportation order in order to give the court jurisdiction to be able to grant a stay. In Benhen, which follows Akiampong, Mr. Justice Dubé indicates, well, he puts a gloss to what Mr. Justice Hugeson said by saying that even where you don't directly attack the order, if the end result will affect the validity of the order, then you can properly, the court properly has jurisdiction to grant a stay. In that case, the person was attacking a decision of the Refugee Division. When the Refugee Division says no, a conditional order becomes actual. And Mr. Justice Dubé recognized that if the person was successful in the court on quashing the Refugee Division's decision or having the appeal allowed, that that would make the actual deportation order back into a conditional order. And although it was an indirect attack, it was sufficient to give the court jurisdiction. There are many instances where you're not attacking the validity of the order, where the court has given stays in the past. The case law in the trial division is split. There are cases where Mr. Justice Dubé, Mr. Justice Joel, I mean, you can name them, it's almost all of them, say that the validity of the deportation order is not under attack, therefore the court has no jurisdiction. However, there are cases which say the opposite. If you look at Madam Justice Reed in Hamilton and the Minister of Employment and Immigration, the Associate Chief Justice in Adsoma, and there are 2 other cases recently, Venkoff and Lemieka, again without reasons, but it's clear that the deportation order is not under attack in those cases. The court has found that it has jurisdiction. One of the ways of arguing this, and it comes up all the time on back-end H&Cs, and this was one of the issues in Lemieka. Lemieka, for example, was a back-end H&C. You're not attacking the validity of the order. However, what you are attacking is the exercise of ministerial discretion under Section 52 of the Immigration Act. The minister has a choice as to whether or not to allow the person to leave the country voluntarily and where to which country to send the person to in terms of executing the deportation order. If a person is accepted on a back-end humanitarian review under 114, then the minister's discretion would be exercised in favor of allowing the person to go to the United States, as opposed to sending them back to their home country. You can attack how the deportation order gets carried out, and the federal court recognized